Is Linda Bird. I'm the Director of Programs and Services for the Alzheimer Society of Nova Scotia. So during the COVID crisis, we've been using Zoom to connect with you because we are not doing the face-to-face presentations. So our audience today includes people living with dementia, people caring for someone with dementia, and the general public who just would like to know more about dementia and things to put into place. So as Beth said, we just want to remind you that your screens are muted, so there's no audio and there's no visual today, and that's to keep your voices anonymous. Please use the chat line at any time to post a question, and we'll get to those at the end of the session. So today's topic is future planning, and it's a topic we get a lot of questions about. I'm really pleased to introduce Jessica Lyle as our presenter. Jessica is a lawyer from Dartmouth. Her practice focuses on estate planning and probate since the new probate law came out in 2001. You might have heard Jessica on Maritime Noon, CBC Maritime Noon, or at one of our family caregiver education sessions where Jessica will come and talk about future planning. When not working, busy with her law work, she's busy with her husband and 3 kids and her dog, Banjo, that you might have seen in the promotional poster. So without further ado, Jessica will present for about 20 to 30 minutes, followed by a 20, 30-minute Q&A. So please post your questions in the chat. So I'm turning over to you, Jessica.
Thanks very much. And Banjo's actually here in the office with me today. So while all of you are muted, he unfortunately is not. So hopefully he doesn't see any cats out of the window because he'll be joining the conversation. Yeah, welcome everybody. I suspect there seem to be quite a few of you in attendance. So I suspect that there's probably a few questions that you will all have. As Linda said, I'm supposed to speak for about 20-25 minutes, and then we can open the floor up to questions. We were, when we put together these slides, for any of you who have been to the more extended series sessions that I lead, we've essentially whittled down what's normally the better part of up to 2 hours into a 25-minute presentation. So it's a very high-level conversation about essentially, you know, the documents, the pressing documents that you should have. The Family Caregiver Series is obviously supporting you as caregivers. I tend to approach this as an opportunity to advise you about what you need as well as the people that you're caring for. And so bear that in mind with some of my comments. Some of them, you know, in some cases, there's still the ability to assist your loved ones in getting these documents. And in some cases, perhaps it's too late, but if you don't have them yourselves, these comments apply equally to you as well. So we'll go with that. Now, you are sharing my screen, I'm sharing my screen with all of you. So for some reason we have a blank slide here, but I think it just got added in. So essentially, the reminder today, of course, is that it is always important to plan. We never know what's going to come at us, and the last several weeks of pandemic and everything that's been going on show us how quickly things can change and why planning is important. People who sort of put that off as long as they can, sometimes that's not the best plan. And so really the takeaway today would be, if you don't have documents in place, please take steps to do so. And if you do have documents, but they are over, I would even say 3 years old, but certainly over 5 years old, I would have those pulled out and take a look. To make sure that they do in fact do what we hope they are going to do. And why, of course, is planning important? It's because in this case, to allow any person, but particularly the person with dementia, to be able to keep control. Some people are reticent to come in and get their documents done because they think once it's done that they no longer have control over where things are, that people are going to take advantage and so on. But in my experience, it is often the failure to take control of these documents that ends up being so frustrating and upsetting for people who realize that perhaps somebody's gone to court to be appointed as the substitute decision maker that they would never have appointed themselves. And so again, taking the opportunity to get these documents done is a way to make sure that you're comfortable that the people that are ultimately going to be advocating for you when perhaps you can't advocate for yourself are the people you're comfortable will do the right job. So essentially what we're looking at is to provide a roadmap to our loved ones and our potential caregivers as to what we want to do. And the bottom point is a key one. Potentially you're saving money. I'm going to touch on that shortly, but if we don't have these documents, there are in place various statutory regimes that are to protect everyone in these situations, but they are more labor intensive and costly, and there's often bonding requirements and so on. So that's a very sort of 30,000 foot high level description, and now we're going to get into more of the detail. So typically what we are looking to see is who is it that's going to decide how we are looked after either in life or in death. And so when we are competent, we want our the person with dementia or yourselves to preferably decide who is going to take on these roles. So the roles we're talking about today are, I'm going to briefly touch on the will, and the person typically named in our will is our executor, but more formally they're also known as a trustee and a personal representative. In your personal directive that we will also be talking about, the person named is your delegate if you prepare your document, and in your power of attorney, the person named is actually your attorney. And I'm just going to stop there with a little bit of a heads up. Some people say, oh, so does that mean the lawyer has to be the person named? When you hear the term attorney in Canada, you really should be thinking it's the person named in a power of attorney document. The reality is, sorry, I didn't think about turning off my phone. That's very bad of me. There, silent mode on. The reality is that in Canada, the lawyers that are practicing are called lawyers. We are called counsel. We are called barristers and solicitors, but we are not called attorneys. Attorneys are our sort of colleagues south of the border. So in Canada, when you hear the word attorney, it's really the person that you've named. So if you happen to have a child who also has a law degree, or a family member who has a law degree, or a friend who has a law degree, certainly you can ask them to act as your power of attorney. But attorneys can be anybody. They can be, you know, stay-at-home parents, they can be artists, they can be accountants, they can be anybody that you trust, and we'll come back to sort of what makes a good attorney in a moment. If we are incompetent, then we are looking at what we call a statutory decision maker, and that is again the person that's sort of inserted into those rules by virtue of legislation, and I will come back to that. And as well, if we are incompetent but living, obviously, then the persons named are typically called our guardians or our representatives. Guardian is the term of art that used to apply to any person that was deemed to be incompetent, both minors and adults. Now, for the term guardian, it really only applies to minors, and the term representative applies to adults. If you have attended this session before, one of these slides used to talk about next of kin, and it's certainly a term that we tend to use a lot, but in fact, it's not really a legally binding term for the purposes of any of the documents we're talking about. So again, try to remember that next of kin is more sort of a colloquial expression. And then the other thing I just wanted to touch on briefly, this can be a 15-20 minute conversation on its own, but there's a lot of improper usage of the terms capacity and competency. Capacity is our ability to do anything at any particular point in time, and it's very much a fluid consideration. I can have capacity if I have Alzheimer's and I have a couple of hours that I'm particularly lucid every day, then I've got capacity during that time in many cases, but I may not have capacity later on the day, particularly if we have sundowning or we have other moments of anxiety or stress. Our capacity can change depending on location, depending on time, depending on a variety of situations. Competency, however, is actually a legal term. So when I'm meeting with clients who have dementia, they have Alzheimer's, and their capacity is fluid, whether or not they are competent to sign a document is actually a legal test. So there's sometimes, of course, the need for a doctor's or a medical professional's assessment of capacity, and that's helpful for the lawyer to determine if the client has competency, but it is actually a legal test. So just bear that in mind. If you hear the terms capacity and competency, they are actually separate terms, but they're often used interchangeably. So the documents we're going to be touching on briefly today are powers of attorney, wills, and personal directives. The power of attorney, and I'm just going to take a drink here. The power of attorney is a document that allows the individual that you've named, again, your attorney, to effectively step into your legal shoes and look after everything that is frankly involved with your day-to-day life. So, you know, if you're temporarily incapacitated, it is the person who can step in and make sure that, you know, your mail is collected, that the house or the apartment is secure, that, you know, that your bills are paid, that your groceries are in the freezer, or that at least there's money for somebody to go buy groceries to put in the freezer, that sort of thing. It's the day-to-day tasks that we all face. Our attorney steps in and has to assume those on our behalf. It is a role that's specific to our assets and our day-to-day affairs. So it's financial and property affairs. The person who gives that power is called the donor. So if all of you have powers of attorney, you're all donors because you donated your powers to the person named as your attorney. And again, the person named is the attorney. The term power of attorney is thrown around an awful lot, but in fact, most often if you hear people talking about a power of attorney, they are actually referring to what's in Nova Scotia known as an enduring power of attorney. In other jurisdictions, they are called continuing powers of attorney or durable powers of attorney. So there's a variety of names, but in Nova Scotia, it's an enduring power of attorney. And that's because the intention of those documents is that they will endure even if I've lost capacity. And so some people will then say, does that mean the document can be engaged when you still have capacity? And the answer to that is yes. Let's imagine that all of these COVID restrictions are lifted and suddenly it's safe to travel and everybody says, oh, I've always wanted to do this, that, or the other and go to this destination or that destination, and I'm going to just take the next 6 months and do everything that's on my bucket list. In theory, if your life still has to be kept going back at home while you're off traveling and doing things, you could engage your power of attorney and say to your attorney, okay, for 6 months, you're going to make sure my bills are paid and that my bills are paid and my mail is redirected and that I'm, you know, my life is otherwise continuing here on the ground. But if I become incapable while I'm traveling, so I tend to use the proverbial coconut. If I'm hit on the head by a coconut and I'm left with a brain injury, or my dementia takes a turn that I wasn't expecting and I'm doing more poorly than I was hoping at that point, then the document continues to endure. So the attorney who was acting before, in theory, just while I was traveling, now actually still stays in that role, but they are making decisions on their own. They are not expecting me to call back home and check to make sure that they've done X, Y, or Z. So that's the key. And most often when you go to a lawyer and you have a power of attorney done, it's going to be an enduring power of attorney. That said, it is possible to do a power of attorney that's not enduring. But if that were the case, I would typically say to you, you would still want an enduring one, and then the non-enduring one would typically be for specific purposes or for specific durations. So if somebody is traveling and the house is being sold and they want somebody to make sure that they can represent them for closing. If I know for a fact that I'm going to have no phone or Wi-Fi access from June 1st to June 30th, I could do it for a limited period. Those are sort of those subtle differences which you can talk about with your lawyers. The biggest thing is that you have to be competent at the time you sign that power of attorney, which again is a legal test. And part of being competent is that you have to be at least over 19, because believe it or not, people under 19 are deemed incompetent for legal purposes. So, but the main thing in all seriousness is that you legally meet that test for competency, which again tends to fall to the lawyer at the end of the day, depending, you know, again, some will have medical information or letters from doctors to sort of back up their assessment, but it ultimately is a legal decision. Sometimes I cover things in slides because I forget I've got them later on. So we've talked about general powers of attorney, again, general enduring or a general power of attorney that's not enduring. And we've talked about specific, again, time frame or specific activity. So we've covered that off. The biggest point on that is, on this particular slide, is points 2 and 3. I mentioned earlier, part of what we're trying to assess in naming a power of attorney is what qualifications, and some people will come to me and say, oh, so-and-so is a lawyer, or so-and-so is an accountant, or so-and-so is, I don't know, some other profession that they think lends itself to the role. That may mean that person is the ideally suited person to be named as an attorney, but it also may mean that they are either too busy, or that maybe they can be trusted with the paperwork, but they are insensitive to family dynamics. And let's face it, family dynamics are a big part of estate planning that should always be given some consideration. So the issue of trust is a big one. And sometimes I have clients who say, oh, I'm going to name my grandson or my son Jimmy, although I do notice every time he comes for Sunday dinner, all of my cash is missing from my wallet. Those are not the people we want. There's always, got to be a discussion about what the scope of the responsibility and the ability of an attorney is, because if they act inappropriately, they can cause a lot of damage. So we want to make sure that we've got somebody who's best suited to the role. And sometimes if you've got a person that you're thinking of naming who is, as I say, an accountant or a lawyer, and on the face of it, you think they're the best suited to the role, but the reality is you've got somebody else who's got a bit more time, who's better at listening to various considerations and seeking advice. It may be that that person is the better suited to the role. But the final point that I want you to take away is that you should always have a couple of people in order. So you should have a primary person, then you should have at least one alternate, because we never know if that first person can act. They could be sick themselves. They could have been involved in an accident with you. They may simply just not want to take on the role because the family dynamics have gotten a little crazy. So it all depends, but it really is important to have at least sort of a primary attorney, and then at least one backup, and possibly even 2 or more. And the related question that some of you may be asking is, does that mean we should name, 2 or more at the same time? My practical advice is that, 8 times or 9 times even out of 10, we don't need 2 people to act together. And that's because if they have any differences of opinion that perhaps get a little more heated than we had hoped, that can freeze everything, including the donor, again, the person who gave the power. It can freeze all of their accounts. So suddenly the donor is sitting there, unbeknownst to, the donor, but known to everybody else, to be sitting there unable to get the support and care they need because their accounts are frozen, and the banks, for example, don't know who to deal with because everybody seems to be fighting. That's sort of a worst case scenario. But back to the banks, the other practical issue is that these days, of course, so many things are done online. And frankly, if we're asking somebody to essentially step in and take over our lives, we do want to make sure that it works with their lives as efficiently as possible. And sometimes that means that the only time they have to catch up on their banking is, for example, at nighttime after the banks are closed, but online banking should be an option. When you have 2 or more people named as a power of attorney, quite often, I'd verge on saying always, but I can always be proven wrong, but 99% of the time, banks will freeze online access to view only, so that both attorneys could be on the phone saying, okay, do you see how much is in this account? Do we both agree we should write a check? But the banks won't necessarily let them do anything on the computer because they can't be sure that those 2 people are on the phone agreeing that things should be done or not done. So they will typically say you either have to come into the branch in person, or you have to sign checks where you both sign the checks, and so on. So that's just a consideration when you're thinking about who to name and what order and so on. Picking up on that point and moving into the personal directive, the personal directive is the document looks after our physical person. So it's the document that, most people will think of a living will, for example. That's, again, more of a colloquial term as opposed to a legally defined term, but a living will is sort of our end-of-life instructions. In other jurisdictions, personal directives are called advanced care directives and advanced health care directives, and so they're known by any number of of names, but it's literally everything to do with our physical person. And in Nova Scotia, as I say, it's not just healthcare, it's also living arrangements, clothing, social activities, all sorts of things that involve anything to do with our person. I used to say before this COVID pandemic that it included, you know, in my personal directive, making sure that my hair stayed dyed. Apparently I can't take control of that myself entirely right now, but that's a whole other thing. But it's literally everything that has to do with your person that is important to you. I have some clients who say, I don't care how progressive my dementia gets. I want you to make sure that somebody paints my nails weekly. Or I want them to advocate that I have a room with a view, or things like that. So anything that essentially, you know, affects you personally, spiritually, all the rest of it. The personal directives legislation in Nova Scotia only allows you to name one person at any particular time in any particular role. In theory, it's possible to name somebody to look after your healthcare and somebody different to look after, for example, all the other components of your personal care, including living arrangements and so on. But I would always caution you to be careful with that because amongst other things, we always want to make sure that there's no conflict. And so if I name my daughter Jill as my medical care delegate, but I've named my son Jack as the person in charge of making sure I'm put in the right place, and he happens to put me in long-term care, and there's a doctor on staff at long-term care, all of a sudden we get into a conflict about, okay, does Jill have priority or does Jack have priority? And then again, we've got this problem where there's no clear appointment, and that defeats the purposes of the legislation. So we have to be mindful of that. The power of attorney, as I mentioned, could be engaged while you're still capable and competent, but just unable to look after things because you're traveling or what have you. The personal directive is different from that insofar as the legislation is very clear that the personal directive is only engaged and valid when I am incapable of making those decisions myself. So typically that means I'm either unconscious or it's clear that I'm not lucid. So, you know, in my example earlier, if I have Alzheimer's and I have a couple of hours in the day, midday, whenever it is that I am particularly lucid, then frankly, to the extent that my delegate is still involved with my care on a day-to-day basis, part of what they should be advocating for is that all of my appointments are made in that window that I'm lucid so that I'm still giving instructions and taking control of my life as best as possible. Putting all of my appointments at a time of day when I'm rarely, if ever, lucid is not in my best interest. So it brings us back to making sure that we've named people that we trust who will advocate for us the way we want to be advocated for. I've talked about that slide. I forgot to check with Linda, but I think possibly you can get these slides afterwards, so they can be a little how-to reference for you. Anyway, personal care decisions, as I mentioned, it's vast. It's anything to do with our physical person, but in the legislation, it specifically says, you know, lawyers love to say something broad, and then they say, without limiting the generality of foregoing, here are some specific examples. Well, that's exactly what this legislation does. It says personal care is defined to include these particular items. So, you know, nutrition, healthcare, hydration, shelter, residence, clothing, all of those things that literally have to do with caring for us physically. Being mindful of the time very quickly, if you do not have a power of attorney or personal directive, that's when our statutory regime kicks in. And in Nova Scotia, we used to have a piece of legislation called the Incompetent Persons Act that was essentially laid to rest on December 28, 2017, when the new Adult Capacity and Decision-Making Act came into effect. And we call that the ACDMA, because there's nothing like a good acronym. But essentially the ACDMA allows for a judge to appoint somebody to look after us with a view to our financial affairs and also our person. So in some cases, if I have a valid personal directive but not a valid power of attorney, then somebody may apply to be my representative under the ACDMA, purely to do with my financial affairs. Similarly, I may have a power of attorney, but not a personal directive. In the personal directive legislation, there's actually an order of people who are presumed to step in to be your delegates. But for example, it ranks all of your children on the same footing, assuming you have more than one. In which case, if they're all fighting amongst themselves, somebody is going to have to go and make an application under the ACDMA so that they are appointed. So in any event, this is sort of our catch-all. The problem with this legislation is, of course, it's cumbersome in the sense that there's a judge involved, there's several supporting pieces of paperwork that's required, including a capacity assessment, but other documentation as well. So I always tend to tell people, you're typically looking at probably sort of a $4,000 to $5,000 exercise to go to court in order to be a representative, whereas you can typically get a power of attorney done at a fraction of that price. So I'm always going to say to any presentation group that I meet with, if you take nothing else from this presentation, please make sure you go and get a power of attorney in particular, because as I mentioned, it's possible that while somebody's trying to figure out who will be your representative, that your accounts are frozen and so on, and you want to make sure that people are able to look after you. So being mindful of our time, very briefly, we just threw in a couple of slides about your will. So your will is essentially the document that reflects what you want done with all of your belongings and your affairs when you are deceased. So I tend to say it takes a snapshot of all of the stuff that you've accumulated over your lifetime, and it says to the executor, okay, here is how I want you to deal with all of this stuff and wrap up my life. Your executor is the person who carries out the terms of that will. So it's similar to what I was mentioning about who to name as your attorney. The reality is that you want them to be trustworthy. Again, if I have a very shrewd accountant or lawyer child or some other professional, or frankly, not even a professional, but just somebody who seems to be more with it with numbers, but they are completely disconnected from the emotional side of life, that may not actually be the best person for your executor, because a lot of dealing with an estate is also the aspects of sort of maintaining family harmony if possible, and trying to settle any disputes and not reacting emotionally when everybody is very upset and stressed out at that time. So it's an important decision in terms of who you're actually naming as your executor. And it shouldn't just necessarily be, I'll just name the oldest, because the oldest child, if you have children, your oldest child may not be best suited to the role. It may also be a geography issue. If there's somebody closer, you may lean towards them. But at the same time, in this day and age, maybe sometimes geography shouldn't be an issue. So again, a lot of considerations that I encourage you all to discuss with your lawyers when you are talking to them about wills. We've given you a couple of things to consider about choosing an executor. As I've touched on, it's possible that your executor could live outside your province. There's an argument to say that the person should live inside your province. It does make some aspects of the job easier, but also if you have somebody named outside of your province, you need to make sure that there's language in your will so that they don't need to actually have what we call security or bonding in place, which in Nova Scotia is the presumption. If an executor is named who is not resident in the province, because they are not immediately subject to the courts of Nova Scotia, they have to be bonded to make sure they do no wrong. So we've got some information there. And we've also included just a little summary again of primarily the personal directive and the enduring power of attorney. And I think, Linda, that brings us to our question slide. So if there are questions, I'm happy to take them. I think you're muted, Linda. I can't hear you.
Thank you very much, Jessica. That was a lot of information in a very short time, so you should get an award just for that.
Oh,
as you said earlier, this is usually a 2-hour presentation and you put it down to 30 minutes, so thank you. The good news is we are recording this session and it will be on our YouTube channel for now in the future, and that's a really good thing. Now, because you might want to, after you've heard the whole thing, go back and see it again. You might want to share it with some family members, get all on the same page. And I know that there was someone from the community college watching. You can use these videos as teaching tools in the classroom. So thank you for that. So we do have some questions. One question that came in was, do you have a rough estimate of what it would cost for a couple to have their wills done now? And do you need a lawyer to have your wills done?
Yeah, I have several answers for that, but so it is possible in Nova Scotia to write a will on your own that can be upheld by the court. And frankly, in these days of the pandemic, if you have nothing and you're not sure that you can meet with a lawyer, and I'll come back to how to do that in a moment, then certainly it's better to have something down by your own hand than not. The problem is, for example, typing something and printing it and signing it is not legally binding. If it's not executed the proper way, it's not legally effective. Or I should say, it's not legally effective automatically. It involves going to court and having proof that it really was intended to be your last will and so on. So writing your own will is possible, but it can be problematic. Similarly, will kits, so I don't make a point of doing estate litigation. I have some files that unfortunately have a litigation component, but there are lawyers who love litigation and focus their practices on that. They love self-written wills and will kits because they are frequently, as I say, I've got an estate right now, for example, where the will appears to have all the tests so the person writing the will is called the testator or the testatrix. So it appears to have the testator's writing throughout, but I'm confident it was done in 3 different sittings because there's different colored pen, there's different, like, stronger, sort of more vibrant handwriting at one point and then shakier handwriting later. So I think they just kept pulling out this document and tweaking it. And at the end of the day, we are going to have to go to court to have a judge agree that this will in fact is reflective of the deceased's intentions. So, again, would I say if you had no other choice or you couldn't get to a lawyer or you didn't absolutely refuse to go see one, will a will kit help? It will in some respects, because if the executor is named properly, it may, hopefully, if done properly, avoid that bonding issue I mentioned. But I've only in the last 20 years had one will kit will where we've been able to use it without issue from beginning to end. So again, in 20 years, I think the odds are not great that the will kits are going to serve every purpose. So bringing you back to the question about the lawyers, honestly, it depends on the lawyer. In my firm, we never let clients leave without having complete estate planning. So we want to make sure that everybody has a proper power of attorney, a proper personal directive, and a proper will. At our firm, we say you should assume that package is going to cost you, assuming we've got all of those documents and we've met with people, we make sure. We don't do that planning for less than $850 from beginning to end. It's just not worth it to have a rushed conversation because, again, your family and loved ones pay for it on the other end. Are there lawyers who are still doing estate planning for possibly, $500? I suspect so. I'm fairly confident that's probably the case. There are some lawyers who use the same will for every client, because they think a validly executed will is better than nothing. And that, I'm going to tell you that I would take that over probably a will kit. But on the other side of it, as I mentioned, in terms of the probate files and the litigation, this is where we end up seeing a lot more cost that's borne by your loved ones because I'll give you an example. I had an estate at one point where the 2 children were named as co-executors and they were supposed to get everything, the will said, give them everything equally. And they spent 4.5 years fighting about what does equal mean. Mm-hmm. And they were so busy fighting that, it was a long haul just to get them to agree how to divide this estate 50-50. Had the lawyer had a bit more of a deep conversation with the parent to say, okay, you have a lot of real estate. I see you've given some things during your lifetime, and I see there's other things that you've identified here by notes. Like, what do you mean? What are you looking for? We could have probably got all of that solved within a year. So, that's the sort of the Coles Notes answer to that, is that it's always, I think, better to go get professionals than not. You risk things. if you don't get, it's that adage of you get what you pay for, unfortunately. Which brings me to the last point I wanted to make. Right now, with the current restrictions in place, many lawyers, in fact, most lawyers are not meeting with clients in their offices. It's just too much of a risk for the client and for the lawyer. So there's a variety of things. There's a number of lawyers who have been using technology, and we're taking extra steps to try and sign wills by video technology, which many other provinces have risen to the occasion. They've got some Band-Aid legislation that specifically permits video conferencing for will execution. In Nova Scotia, that is not yet the case, but I'm part of a group where we keep lobbying the government to do that because there are numerous people who have signed wills in that matter over the past 2.5 months. There's other lawyers who are meeting with clients in their parking lots or in backyards or front yards or whatever and trying to sort of sign in a socially distant manner. There are, as I mentioned, strict formalities about how a will can be considered validly signed. So it is important that when all of your hard work goes into this document that you make sure you see it all the way through and get the document signed properly.
Boy, COVID is affecting us in all kinds of ways that we didn't predict.
Absolutely.
So another question that's come over is what is the definition of next of kin, and how does that, I think there is a hierarchy of next of kin, is there not?
Well, again, next of kin isn't really a term. So, in the powers of attorney legislation, the person is the attorney. In the personal directive legislation, the person is the delegate. In the will, the person is your executor or your personal representative. I think the hierarchy, though, that you're thinking about is in the personal directive legislation. In that legislation, it says that if you have, so back to my example about not naming an alternate. If I name my spouse as my delegate and I don't have anybody named as a backup, but otherwise my document says what I want done, then if my spouse can't act because we were both hit on the head by coconuts at the same time and we're both left not thinking straight, then there's a statutory list, right? A list of statutory decision makers. And that priority goes spouse and then adult children. And if not children, then parents. And then if not parents, then adult siblings. And then so it's literally sort of follows a family tree. The problem is, as I said, it doesn't rank. It doesn't necessarily say the oldest one takes priority. So we have to be cautious. That's where we get into arguments where, family members say, well, youngest child lives here and is more actively involved and should be the delegate, and the oldest one presumes they're named. And so, the reality is you are always much safer to put in writing the order of how you want people appointed than just necessarily leaving it to the statutory default, because that default, again, assumes that there's still going to be agreement within those classes of individuals, and there isn't always.
And we have complex families now. We have common law, stepchildren, and so maybe somebody's more closer. You wanted to name one person over someone else. So it really is a gift to put that as in much detail as possible for everybody.
I see that a lot, actually, Linda, where maybe the biological children are in other provinces and it's the stepchildren who are local who have actually been helping out mom and stepdad, or dad and stepmom, and then suddenly the parents get sick and the step parent gets sick, and again back to that statutory regime, stepchildren aren't included in that ranking of children, and so that is absolutely a problem. I've got a couple of those files on the go right now with everything that's been going on, where we're trying to figure out who to get in because the actual default doesn't reflect the family reality.
I know from my own personal experience and also through working at the Alzheimer's Society that sometimes these conversations are difficult to start with an older family member, about thinking about things that you're going to be using at the end of your life, like a will. Any suggestions, even advanced directives, right? Because you're talking about a time when you're no longer able to make those choices for yourself. And sometimes it's very emotional. Do you have any tips on how to start those difficult conversations with families?
You know what? My first tip is always have the conversation. depending on who's starting it, sometimes it's hard for the parents to start it because some children are like, la, 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 I don't want to hear, I don't want to think about a day when you're not yourself. In which case, frankly, I always say to the parents, you're not going to need to sit them down like they were still children and say, I need you to listen to me right now because this has to be dealt with. On the reverse, you know, the reality is that sometimes for children who are trying to raise it with parents, particularly parents who perhaps already have some dementia and are unsure and concerned, then sometimes I actually use this as an example where they can say, oh, mom or dad, I was talking to a lawyer myself today and I'm thinking about doing my own planning and this is what I'm thinking, and then sort of gently lead that into a conversation about them. And as I mentioned early on, sometimes saying I really want to have control so that I know if I can't make decisions, I've named the people I want. Who do you think that should be for you? It can sometimes soften the conversation and have it unfold in a way that is not suddenly focused on them, on the person who's the recipient of the conversation. But, you know, if it's me with my parent, I may say, I was talking or I was reading or I was doing something and I'm thinking of this because I think, you know, this child may be a little too pushy. I think this is the person. And then segue that into a conversation with the family member. And then the other times it's just, even if there's somebody neutral who can be invited over for tea. And similarly, I mean, invited over tea is challenging right now, but as the weather gets better, maybe at a picnic table. But have that conversation as well and bring it up so that it's a more general conversation as opposed to pointed right at that person.
Yeah. And you're right. That's a nice way to start, is say that we all need to have these things in place. None of us know what's going to happen from one day to the next. You know, that coconut could fall on our head, right? So it really is a planning tool that everybody should use, and maybe talking with your spouse or your parents or whoever, everybody do it together might be a way to soften it.
It
also can be, it can be a real relief to have it done and think, you know, in whatever case happens, and you might even learn things about one another that you didn't know. The other thing is different family members might make assumptions about what somebody else wants. So it's really nice to go to the person and, you know, what do you want? What are your priorities? And have everybody hear the same thing. Right?
Yeah, because everybody hears different things. That happens all the time. And so I always like to facilitate. So I do a couple of things. So some of my clients, we actually have family meetings here where we walk through what the documents are and try to get the things that my clients are particularly important are out in the open, said in a way that, you know, we've got notes and we can say, yes, we all talked about that. The other thing that I do in my practice is for the personal directive in particular, which is so particular to the individual, I have my clients sign enough originals that each person who's named in that order, as I mentioned, so if I've got 2 kids and I have my spouse named first and then each of my children, I want everybody named to have an original. And as I give that to them to hold on to and say, hopefully you never need this, but if you do need it at some point, you've got one. By the way, I'd like you to read through this now and ask me any questions, because one of the things is, often, do we want to stay at home as long as possible? Do we want to be moved into long-term care? I've certainly had a lot more conversations. You know, I've tried to have conversations for years, but clients are taking me up a lot more on the conversation about what are the best scenarios for care? What are those options? And a lot of it is we don't know what it's going to look like at the time you need to have those conversations, but it's important that the people you're trusting to be your advocate have a very good handle on where your mind is at in terms of what your preferences are, so that when they are making a decision for you, if you become lucid suddenly and you find you've been placed in wherever you happen to be living, they've actually made the right decision and you're not picking up the phone and saying, what were you thinking by moving me here?
So that's another question that came up is, for a personal directive, do legally people have to have a personal directive as they go into long-term care?
I wish legally everybody had to have all of these documents, but legally, no. That said, I think most of the long-term care administration teams are insisting on having a personal directive presented at the time of admission. So if they don't have one, and for those of you listening, the province rolled out this new legislation in 2010. And so if you search Personal Directives Nova Scotia, the government has a great website, and they have a sample directive on there. They've got what I think they call a short form one and a long form one. And the short form one just says the people you want to be your advocates or your delegates really, in the order that you want them to act. So again, if I have my spouse and then Jill and then Jack, or Jack and then Jill, whatever, in that order. The longer form one, it allows you to fill in more detail, but the risk again is that sometimes people think they can name different people for different roles, and sometimes that conflicts. So bear that in mind if you're looking at it. But in my experience, when I have some of my clients, or when I'm helping family members more so than my clients going into care, and I say, is there a personal directive on file? I will often see that short form one in a long-term care file. For those clients who have presented without one, then the social worker or the admin person will say, okay, well, I'm just going to print off this one from the government website. At least fill that out so we know who we should be talking to if we can't get directions from you.
So here's a great question. I think it's covered a couple of things. What if there's a conflict between the person who's power of attorney and the person who has been named the delegate for the personal directives?
Yeah. So again, it depends on what that issue is. Remembering that the delegate has been appointed to deal with anything to do with your physical person. Mm-hmm. If my delegate wants me to be put in to stay at home, for example, but with more care, or to put me into long-term care, but into one of the nicest possible suites they can find, then the conversation with the attorney is supposed to be, can you pay for this? Is there money to afford that? Mm-hmm. And that's where, if there's a dispute, it will often come up because the attorney should be saying yes, assuming there are funds to do it, or no, but no because there aren't sufficient funds, as opposed to no because I want to keep as much money back as possible so that when this person passes away, our inheritance is larger. The law says that the person acting as the attorney has to put the best interests of the donor first, as opposed to the best interests of the donor's estate. So, you know, your stereotypical news article where there's things gone awry are, you know, Jack and Jill are named, one in the personal directive, one in the power of attorney. Jill is named as the delegate, and she wants me, mom, to stay, I don't know, in the penthouse suite at Shanix. And Jack, however, says no, because then all of the money is going to be gone in 10 years and there's no way, or money's going to be gone in 1 year. So if the conversation is the money's going to be gone in 1 year, then Jill needs to go back and say, okay, I can't put mom in the fancy suite because then she's going to be out of money, and that's not the point of this. But if there's enough money for me to stay in a penthouse suite and it's not likely to run out for 10 years and I'm 99, then chances are my attorney, Jack, should not be saying no, because that's really just likely him thinking about future inheritance as opposed to what's in my best interest. So as long as I'm living, my money is supposed to be used on me and for my best interest, and anybody who is swayed differently is potentially going to be taken to task by a judge, because in that scenario, the conflict that would result would likely have the delegate sort of winning out that no, there's no reason not to do this, and a judge would sort of review what the attorney is doing.
And I think I'm going to refer people back to the table where it clearly lays out the job and the responsibilities of each of those different documents and who you're naming. And there is very clear roles, and you're always supposed to be acting in the best interest of the donor, right?
Exactly.
Yeah. So thank you very much. You've covered a lot of information on a brief time. I want to remind people that you can, this will be posted on our YouTube channel sometime in the next week, and share it, do it again, share it with families, send your questions to us. So next week we are moving to Thursdays for the summer, and we will be meeting at the same time, 1:30 to 2:30 on Thursdays, using the same Zoom channel. The topic next week will be dealing with strong emotions during COVID, with Dominique Boyd as one of our speakers. If you have any questions or concerns that came up from today's presentation, please call our office at 1-800-611-6345, and we'll have an info line staff connect you with your resources and answer your questions. Thank you today, and special thanks to Jessica. We really appreciate you talking today about financial planning and the importance, and I hope it all motivates us all to go back and check that we've updated our documents, me included. The final thing is there will be a short, one question coming up to provide some feedback on the session. Yeah, there it is. So if you would take some time to please answer that, we appreciate it. And have a safe weekend, everybody. Thank you so much. Bye-bye.